Good evening, everyone. Thank you so much for joining us on a Tuesday evening to enjoy the delights of one of our first seminars together. We're so grateful for Garden Court hosting us today. It's a fully booked event, and it's so nice to see so many familiar faces today. So what are we going to be covering today? In some long marriages, particularly those involving significant assets, complex conviction can develop, especially when there are international elements and shareholding between spouses. So this seminar is going to be a journey, working out whether you need evaluation, process of applying, what outcomes you might seek, some real life war stories. There'll be an opportunity at the end to ask some questions. We will have a Q&A session. And we have a panel of experts, some of who you will recognise and have worked with already. So who am I? I'm Michelle Uppel, and I have the pleasure to chair and time manage conversation in this panel, which is going to be a task in itself. I'm a solicitor, partner, mediator, collaborative lawyer, and I work at a boutique family firm, Lowry Legal, which was established in the northwest of England during COVID. I set up the London offering of Lowry Legal about 18 months ago. My own practice has evolved over the years, and I've found that I'm working increasingly with international cases involving a family business where there is a spouse who had no active involvement. And so this idea of the seminar was developed from that very issue, having worked on a number of cases with Stephen, and where we all met to discuss the seminar. The first question I asked, why do you involve a spouse when it's all too much trouble when the relationship then breaks down? And that question will be answered during the course of this evening. So our first speaker this evening is Ed Elliot, barrister, Garden Court Chambers, who has over 20 years of experience assisting clients with matrimonial pleadings, breakdowns, and Ed has significant experience in complex cases involving third-party assets, interests, valuations, company assets, international elements. And since 2019, Ed has served as a Deputy District Judge at the Family and County Court and sits as a judge in the Financial Remedies Court. Ed has decided to entitle his talk after something his geography teacher said when he was 12, always know where you are going. Ed is going to cover the need for experts and the factors to help you decide what to include. Our second speaker is David Muggridge, owner and director of Auckland Web, which is an accountancy and tax advisory practice that serves a wide range of business, charity and private clients across the business sizes, types and sectors. David is a chartered certified accountant and an accredited expert witness and has over 20 years of experience as an expert in a wide range of instructions. But more importantly, David is a lifelong Gary Newman fan, F1 fan, visit Silverstone for the Grand Prix weekend every year. And last year you did over 25,000 steps, 3 days, and took over. Dave's talk is called A Road to Nowhere and will explore whether to appoint an SJE and the practicalities of either route, what's needed, how to deal with the expert, frame questions. So our next speaker is Olamide Ogunrinade, barrister, Garden Court. She does it all. She does public law proceedings, private law proceedings, financial proceedings, tilata, and enforcement orders. Olamide once walked barefoot across hot coals and treated herself to taking up roller skating on your birthdays. Interesting fact. Olamide will focus on procedure, how to make an application, and then go through the Daniel and Walker applications also. Next, Aaron Fermahan, Senior Associate at 458 Law, a specialist corporate law firm. His practice covers corporate advice across a range of industries, and Aaron partners with startups, venture capital-backed companies, aggregators, which I have no idea what that is. Apparently it's a new term. That's
relatively new
term. Investors, sellers, founder owners, helping to buy, build, plan and exit business. Both Aaron and I part of Exceller Law as well, which is part of the House of Brands, and we work in the same office. And Aaron is my go-to company lawyer when I need some help with technology and tools. Fun fact of Aaron, he was best man twice. First wedding involved fire inside Kew Gardens, and the second time he was best man, the tree collapsed partway through his speech. Best man again this year in Portugal, so let's see what happens. Aaron will cover company law mechanisms, options available to enable a company to operate continuity post-divorce. Last but not least, we've got Stephen Liu, barrister, Garden Court. His practice covers it all as well. Children matters, complex international cases, financial remedy proceedings, modest assets, as well as multiple jurisdictional cases. Stephen advises on pre-marital, post-separation assets, inheritance, pensions, and was shortlisted Legal Aid Lawyer of the Year 2021 for Barrister of the Year. Stephen is, most of you will know, is a swim coach. He keeps an eye on everything beautiful, loves yoga. It's incredibly Stephen will share his war stories and wisdom. So I now hand over to Ed, who will begin.
Hey, thank you very much. Good evening, everyone. One of the things I think we're probably all taught when we are training is to be, you start at the end of the case, where you want to get to, and then you work backwards. When it comes to financial remedies, I think there is a temptation to get sucked into the process. Yes, you've got to prepare the full me, you've got to prepare questionnaire, you've got to prepare for the FDA. There are stages on the process. The point of this is to remember at the beginning that probably asking your client, where do you want to get to, is the most important thing to ask at the beginning, because that will clearly have an impact in the directions that you're going to seek. It's clearly going to have an impact when it comes to the business issues that we are talking about, whether you want an expert. So, starting. All of these slides, I think, has been said already, are going to be available. So I'm not going to speak to everything, but otherwise the book will come out and pull me off the page as I will be going over time. But this is just some of the questions that I think you need to ask yourself at the beginning. The key points here, I think, are not to get tied down necessarily. If you are for the spouse who is not the person running the business, don't get tied down as to were they a shareholder, were they a director at some point, were they an employee, what role were they playing? Because if you look at the business, you think, well, this isn't particularly significant, or is it really worth anything? Well, you could spend a lot of money establishing the value of a nominal shareholding to say, well, this is joint, but 50% of nothing is still nothing. So actually have a look at whether it is worth it. The next point arising from here, beware of double counting. So it may well be that you are saying, well, if you look at the income that more affluent spouse is getting from the business, you look at the kind of mortgage capacity that that will generate, you're going to be looking to depart from equality into how you address needs here. On a sharing basis, you're going to depart from equality because of what the business will generate. You've taken all of that into account. Do you really need to circle back and then quantify the value of business? Because let's face it, whilst there's lots of expertise that people like David can bring to the table, it's a significant financial commitment if you are going down the route of engaging this kind of valuation report. However, this isn't all doom and gloom, or don't do it, because there are cases where you are going to need evaluation. Sometimes you need it because business creates an unknown. It's a blockage to settlement unless you can resolve certain issues around the value of the business, around what income is the business generating. A business valuation can provide an evidential basis to assess the value of the business, whereas otherwise there would be no clarity at all. What I would say, and this is something David and I discussed when we arrived earlier, that there are cases, and you've obviously heard about expertise of my colleagues and I in children work. So if you get an expert in a children case, there's an injury, you've got a radiologist. Well, it's often very difficult to get behind their kind of expertise. More often than not, however hard you try, the judge is going to follow what the expert says. These are different kinds of reports, because in many cases, what your expert is giving you is a sound basis for an argument, a basis for saying, well, you should go down this approach of valuing the business. But it's not necessarily as definitive as other kinds of expert. They are departed from a lot more than other kinds of experts in other kinds of proceedings. But nevertheless, it gives you a basis around which a debate can flow about what value should be ascribed to this business. Gives you a starting point at the very least, if not a final answer. Sometimes you are stuck without that. And sometimes you need to prove a negative. I have just finished today evidence at submissions on a case, judgment in the morning, where one of the big issues in the case is what value should be ascribed to this restaurant. And our case was we wanted it to be got a valuation. The expert said the business is worth nothing. Actually, money well spent, notwithstanding the conclusion. The other thing, of course, is it is not unusual for there to be a business downturn to coincide with matrimonial finance proceedings. It's sometimes by design, but also sometimes not. It can be that financial downturns are explain why there's been a separation. There are arguments about money. Other times there is a financial downturn because you can't give your best to your business when you are caught up in difficult matrimonious proceedings. But all those things need to be borne in mind when assessing whether to go down the route of evaluation. So what factors might help you decide? I think in many ways, these are things to go through and look at, think about in your own time. I'm not necessarily going to talk to all of them. I think what I would say is some of these factors clearly point towards there being evaluation. Some of them clearly point against. And probably the theme that runs through them is to what extent do you actually have a business that is what a company is, which is a separate legal personality. To what extent is it an independent entity, or to what extent is it just an extension of the person who is running the company? And to what extent is it significant? So all of these factors go to that. And then developing those points, these are the points that point to where evaluation is more likely to be necessary. So to develop what I've just said, where it's important or significant part of the assets, where it really is an independent entity. So if it makes something, if it has a number of employees, if its trading does not depend on one or two important individuals, there could be a market for it. So, the example I've just given, the restaurant, obviously, well, people do sell restaurants. Another case I've got involves various different disappearing dental practices. Well, that can often be quite a lucrative market. The fees that dentists can charge, new dentist moves in, takes over the patient list, well, that can be often a market for that. And what a valuation often is, I mean, any asset, what will a judge always say? Well, it's worth what somebody else is willing to pay for it. And so if you've got a business that clearly could be sold, dependent entity, that's probably the soundest basis there is to say, well, let's get a value, let's get a valuation. That might actually be something worth having. A valuation will not be necessary. I guess where one of two circumstances, three circumstances, I guess if we say on this slide. So everything we've got here above the line, in some way or another, the top four, there is a different way of knowing what the business is worth. Now, often what we're dealing with, in this case, we're dealing with micro or small businesses, occasionally medium businesses. Because things that are bigger, well, their documents may very well propose how they would be valued. There may well have been trading in shares of these businesses, and obviously if they're really big and they're quoted, well, you can work out what the business is worth without leaving your desk. You just look up the share price. And that's part of the complexity, because the smaller, the medium, the micro-sized businesses, well, they are the ones that are hardest to determine is there a market for, hardest to determine whether they do have any value, which is the complexity and the difficulty in this subject. The bottom two, if it's modest, probably ignore it or find some other way to take it into account without throwing the money that a business valuation requires. And then the bottom one is often, I think, the most important point, because one of my slides we'll look at in a minute, different kinds of businesses, and just talking through when you may or may not need a valuation. But there are a lot of people that earn money, often in the 45% tax bracket, that will earn through a company, because that is the most tax efficient way of doing that, a way of avoiding 45% tax. But nonetheless, business may be an income stream. It may be no more than a tax efficient way of your key person or a couple of key people earning their wages. And it is not unusual, those kinds of businesses, on the one, you've got one party, the person not involved, saying, well, this is incredibly lucrative. You've got the other person who then start saber rattling to say, oh yes, but IR35, and it's probably not going to last. Now, I don't know to what extent, probably some of you are familiar with the concept of IR35. I'm just going to touch on it briefly. That it's the idea that as to when does a contractor, often working through a company, when are they a contractor? When are they in fact an employee? Because obviously if you are an employer and you are employing somebody through a company, you haven't got to pay employers' national insurance. You haven't got to pay sick pay, holiday pay, various other things. So it works for employers. It works for employees, because you're not having, you can set off your expenses against tax. You're able to take dividends at a lower rate than you would through PAYE. It's tax efficient. As a consequence, tax rules effectively say, well, if it looks like an employee, then it's an employee. If it looks like a duck, quacks like a duck. And then one of the changes in the rules, because AR35 has been around, I think, since 2001, been around for a long time. But a recent change in the rules is now saying employers have the responsibility. So if you have got somebody on a contract, they should be an employee, but stops with you. So you will often have this tension cases with somebody saying, well, this is very lucrative. The other person saying, well, no, it looks okay at the moment. When I come to renew my contract, well, they might even try and put me on a PAYE basis. It's not all it's cracked up to be. But if you've got those kinds of issues, very, very likely you don't need business valuation. That's the point. Okay, so key principles. 2 minutes. I told you, the hook will come out. I might take slightly longer on the basis I think it's not too long. This is the key, one of the key cases, the hotel case. You can look at these slides in your own time. The main point of this is being careful, because a business valuation is not necessarily a magic answer. Valuations of private companies can be fragile and uncertain. The reliability of valuations will depend on factors such as, on it goes, there's 6 there, 4 more on the next slide, and there are all sorts of things that can make it very difficult to rely on a business. If when you've got the valuation, well, is it worth it? Here we go. Next slide. Is it worth it? Well, this is just a very quick example case law from Judge Hess, and as you can see, Olamide is going to tell you what bless you, is going to tell you what a Daniels and Walker expert is in due course. But you've got 3 different experts here, 60 million quid between the 3 of them. You might think, what are these experts up to? David's going to tell you. But this just illustrates, be careful. You've got these 3 experts. They must have spent a fortune on this. What did his honour find? He found, actually, this business is just worth the income stream, just worth the distributable profits. In other words, if you had all the information, you had all the company accounts, balance sheets, you could have probably worked it out on the back of an envelope. So, careful. That's double counting. I already made that point, so I'm going to skip. There are alternatives to get more information about the company to just bringing in a business value. In your questionnaires, you've asked for 3 years of all of the information. Well, that gives you may give you a meaningful average, but push for it. Don't just be bogged off by 1 or 2 lots of accounts. And don't forget Companies House, because a lot of information, not everything, because some of these small businesses, they don't have to publish all of their profit and loss. But a lot of it, something to give you an idea, is this worth it? It's there, it's public, you can search it, you can help yourself. Business bank accounts, I often find, are very illuminating. And if you're not sure that you want or that you need a business value, you might need other kinds of experts. Maybe you need tax advice as to how to deal with certain assets. Maybe if you've got a restaurant, maybe if you've got companies that hold properties, what actually you need is a surveyor if you want to value a lease, or if you want to know what properties in the company are worth. Actually having a business valuer won't actually take you any further. So examples from practice, very, very quickly. Restaurant, probably yes, even though my restaurant was worth nothing, that was still quite helpful. Dental practices, yes, there's a market. Consultancy, anything with AR5, almost certainly not. Practical services, so you get handymen, plumbers, all that sort of thing. Again, an income stream. Companies that hold properties, well, you need to know what the property's worth. You need to know what the mortgage is. You need to know all of the tax consequences of realising these things. Do you need a chartered accountant to tell you what the business is worth independently? The last one, this is just kind of the most daft thing I think that crossed my desk when I've been sitting at a DDJ over the last year. The bloke had a limited company, he was a lorry driver. Get asked at the FDA or judge whether we think we may need a value of this business. He earns an income, you need to know the value of the lorry. Clearly, you don't need to value things like that. Practice varies enormously. So my last slide, and then I'll stop. I was on the middle money course, judicial training course, in January. We have syndicates, they're called small groups essentially, and I had a very senior circuit judge was my small group leader, one of the judges named on the slides, and we had, are you going to get a valuation of this business? And everybody in the room, him included, it's an income stream. The crib sheet written by a different judge, the judge arranging the course, judge on a different circuit, setting out all the factors, and yes, you're probably going to grant this because it's necessary for these reasons. So practice varies enormously. And you can't necessarily rely on judges to rein parties in, particularly if they're agreement. You've got an agreed position. The judge has got a busy list.
Very much, Ed. We've got David next.
Good afternoon, everyone. Good afternoon. Thank you. It's in the right direction. And for anybody who's old enough to recognise the quote tied in with Ed's, don't know where we're going, road to nowhere, talking heads, I thought it was quite a nice segue in. And what I'm really going to be talking about is not anything to do with valuation, even though it pains me to have to listen to someone else talking about company valuation. I'm going to be talking about what really you need an expert for and how you might use an expert, and then talking a little bit about some of the things that come up in terms of the consequences of how you use an expert. So the first point really is, I know that there are plenty of you who will have a good understanding of businesses, financial entities. Certainly council here has a very good understanding, but there are also some of you that will not, or are not confident enough to be able to make that determination, or even for PI reasons, for example, you don't actually want to be making that recommendation or expressing that opinion to your client. And in that situation, you want somebody else to come along and tell you what you think you probably know, but maybe you're not absolutely sure that you know exactly what the answer is. And so the question is, do you then go to think about, right, you advise a client, I think we need an SJE, or do you do something else? I think sometimes there has been a tendency to treat that question as a little bit of a binary yes or no question, but sometimes there is a situation where you might be able to run to a shadow expert, use a shadow expert, even if you don't, and I call it a shadow expert, even if you don't actually use an SJE themselves. And clearly, as you will all very well know, the SJE process is quite prescriptive. There's rules, family procedure rules, there's rules that Part 25 and all that sort of stuff that says what an SJE can do, what they can't do, and what they shouldn't do. And you will be familiar with the notes that I've jotted there about SJEs being able to ask for information, request meetings, supposed to be objective, supposed to be independent. All that's true. But one of the big issues I always find as an SJE is I can only answer the questions that you've asked. So therefore, if you've got the question wrong, or if the question is not quite correctly phrased, I can't say, actually, you know, I know you've asked me that question, but really the real question is this one. And clearly that doesn't happen very often, but it does happen. And as the advisor to your client, I sometimes wonder when I'm preparing a report and issuing a report, I'm wondering if what I'm going to be saying, if my conclusions are what you expected, or more importantly, what your client was expecting, or whether will it come as a nasty shock. And certainly, for example, yesterday I issued a report, and I know that one of the instructing parties is going to be asking some very, very lengthy questions. I'm quite sure that I'm going to get some quite nasty questions, just because I can see the correspondence that's gone. I had a couple of meetings with the parties, and you just get a sense of where the parties sit and what their perceptions are. And so sometimes, so we talk about appointing, and you've appointed SGEs many, many times. You know all the rules about getting the instructions right and covering all the issues. And actually, in reality, these days, I know we're a number of years on from the introduction of SGE, and you are, it pains me to say it, but you are all pretty good these days. So that's not such an issue. But sometimes there are occasions when you think, actually, do you know what? This really isn't worth it. I feel like I'm wasting my time. You've got to do the job, but really, is that the right solution? And sometimes, again, a number of times I have meetings with parties, and also that they don't really understand exactly what we're trying to do. I always start any kind of meeting with the parties or with the representatives, basically sort of talking about what an SJ is there to do, impartial, independent, ask questions, don't try and anticipate my opinion with the questions I ask or how I react to questions and so on and so forth. And it's very difficult sometimes because the parties want to almost start to get you as an SJE actually acting as an advocate yourself, and they want you to see their point of view, their side of the story, and it gets quite challenging. And that's sometimes perhaps a lack of maybe exploring what the process might be and what's going to come out of it. And again, with an SJE, there's an element of lottery here. You think you know what your answer is going to be, and Ed was talking about a restaurant where they got the outcome they wanted. But the other example with the £16 million variance between one answer and the other, and we all know that if you ask 5 accountants a question on valuation, you will probably get 7 or 8 different answers. That's just how it works. And then somebody, the judge, what the answer actually is. And again, with SJE, sometimes what I see is the disclosure, the way the parties disclose information, they don't necessarily help themselves. And one wouldn't ever want to get into a situation of being seen to be telling your clients what they should or shouldn't say. But on the other hand, do they sometimes understand the implications of what they're saying? And things like directors' loan accounts, particularly overdrawn directors' loan accounts, very good example. Business expenditure is another good example where there's sensitive issues, and sometimes they don't always entirely understand what the implications are of what they're talking about. And I'm hoping that was a recognition of something I'm talking about there. So as an alternative to SJE, I do quite a lot of work just as in an advisory capacity, whether it's acting as a shadow to an SJE or whether it's purely advisory. And I prefer doing advisory work if that's a strange thing to say, simply because there are many circumstances where the company might provide its own valuation, the company accountants provide a valuation, and you guys, you're actually not really sure whether all of the elements of that valuation stack up, whether there's any areas that should be challenged, whether there's anything that's been missed. We're not going to talk about the detail of those elements because Ed's covered a few of them already, and I could talk about those sort of things probably for a couple of hours or so. But getting an informal opinion, maybe looking at what the valuation, what the documentation is to be provided with, does it stack up? Does it make sense? Is it worth a client actually going through the whole rigmarole and expense of an SJE if you don't feel like, if nobody feels like it's going to come up with an outcome that is more favourable than what you've got already? And so to be honest, and you have to be honest, sometimes you have to say to your client, like, actually, that company valuation, you might think that because the company accountants come up with it, they would have just put in there what the other side want. But actually, sometimes it might have a fair conclusion and you move on. So even a company that is clearly worth something, take the answer that they're giving you and move on, fight elsewhere. And same with same with the SJE. Dealing with an SJE, sometimes SJEs come up with good reports, sometimes they don't. Nobody can be perfect all the time, except Stephen, obviously. But there are elements in SJE reports that might be challenged, and SJE might be weak in areas. And I have seen areas where SJEs don't have the expertise in an industry sector, and therefore they haven't actually looked at and considered what actual valuation methods, for example, might be applicable in a particular industry. So dental practices, we know there's a lot of consolidation in that area. Same as veterinary services, solicitors, accountants, you name it. There's a lot of consolidation, and consolidators have specific approaches with specific models that they use to calculate the value of the business. In those sort of industries, rule of thumb is quite important, and sometimes they can be mixed. Talking very quickly, SJE, because you know yourselves, getting instructions right is really important, and setting your clients' expectations about the process, what an SJE is there, what an SJE can do, what an SJE can't do. Of course, you know that SJEs cannot decide matters of fact, things like discounts, about quasi partnerships, etc., all those sort of things. They can steer, but they can't decide what an SJE will actually be doing in terms of the level of investigation. We use the word forensic, which is a real problem, because people think that means we're going to go through every single transaction, flick through, is this a genuine invoice? Is it all this sort of stuff? That's not what you do. Proportionality, it's a big thing. Going on our own is no longer permitted, and you don't want it because it doesn't produce an outcome. So does the client understand that? Sometimes they don't, and that might just be something to think about. And then understanding the questions that an SJE is asking. Does your client understand those questions? Do they understand the implications of what they're saying and how the SJE is going to interpret them? Sometimes they actually don't, and that's where a shadow, that's where an advisor can assist. And certainly, as I say, not getting into coaching, but certainly helping to understand implications. And of course, the job that we all love as shadows is critiquing the SJE report. The best thing in the world. Sometimes there are actually good reports, and so you have to say, yeah, well, actually, it's all right. Sometimes you have to say, well, yeah, it's okay, but these areas are not great. Sometimes it's an absolute nightmare, and you have to spend a lot of time just pulling it apart. And then, of course, drafting questions, not just questions dealing with the particular aspects, but questions that are crafted in such a way as hopefully they will lead you on to get the answers that you're looking for, which is the challenge. Shadow expert already covered a lot of these points, and sometimes we prepare our own valuation. Of course, there is an issue that rarely do we have the same level of disclosure. So if we're not talking about critiquing a shadow and critiquing an SJE report, and then looking at an alternative valuation, actually going from scratch, then we wouldn't necessarily have the same level of access. We won't have the same amount of information that is available to the company or to the company accountant or to an SJE. So it's always a bit tricky. We always have to be a little bit careful But usually we can work on something that gives us a starting point, and we can also help you as the representatives to draft questions that might actually elicit the information that we need. And so that element really is quite important. What might be missing, what might not have been said, what should we be looking for in terms of information? Is that reasonable? And we talk about for me and how many times do you read a for me? And the valuation is just the sum of the net assets, is what was on the balance sheet 2 years ago or something. And then it's trying to tease out how that information comes out. Is it a logical valuation? Are there any flaws? What were the assumptions made? So on and so forth. Lots of stuff to play around with. But all of this is in the context of an advisory role, not immediately jumping to an SJE, which doesn't necessarily give you an indication or a steer and doesn't help you to know where you're going. Did you see what I did there?
I like that.
So I've already covered most of these things. Ed also mentioned business fragility. It's a huge, huge issue at the moment. Of course, your client, if it's the non-business spouse, your client has been told by their ex-spouse for umpteen years how well they're doing, how successful the business is. Everything's fantastic. I'm so successful. I'm so wonderful. And of course, as soon as you start in this process, oh, it's doing really badly, not very good, and it's trying to tease out, not only trying to tease out the truth of the matter, how fragile actually is the business? Is it just a temporary blip? What proceedings are going on? Is it actually an economic thing? Is there a change in the market? Or is it simply something completely different? And it's trying to work out those different things and trying to deal with your client's expectations, because if they have been told that, it's really, really difficult to get them to actually understand what the truth of the matter is. And then you've got to realign their expectations about what a potential settlement might be. Thankfully, that's not my job, that's your job. So that's pretty good from my point of view. And of course, it's trying to find out the blanks. You might know what you're looking at, but you might not necessarily always know what you're not looking at. And Ed talked about different types of expert. We also talked about different types of differences. And so just talking about different types of differences, Ed mentioned tax experts. We do quite a lot of CGT work, and that's computational. And generally, a computation is a computation is a computation, theoretically, unless you get complicated stuff where you've got large properties with more than 1.25 acres of land, etc., then you get into the areas of opinion, but generally it tends to be computational. Where you get differences, you can have differences of fact. We were told this, we were told that. Yeah, and you can have experts that get told completely different things. That 16 million difference, part of that may well be that they were working on different facts. I don't know. Differences in what the expert interprets. For example, what's happening with the business. Whether if they've got good forecast, are they expecting to do well, are they expecting to do badly, increases in cost, you name it, all those sorts of things. The differences in methodology, asset valuation, earnings valuation, all these things are tied in sometimes with what is the business really? Is it really an entity that generates profit and it's just the owner spins the flywheel occasionally, or is it something that's income generating? Difference in calculations, calculating discounted cash flow and all those sort of things with interest factors and risk factors and all these sort of things. And experts can have a great time arguing about whether it should be 0.008 or 0.009 and stuff like that. It's totally exciting, isn't it? And of course, the fundamental one is difference in opinion. And that's where we get the issue, as you know, with private companies. It goes quickly, doesn't it? Fantastic. Well, hopefully it goes as quickly for you as for me. And this is where the challenge is: differences in opinion. What you think? What sort of multiple we should be looking at? How do we assess directors' remuneration? All those bits that sit in. And then the big one that you're all really interested in is how much cash is in the business that we can get our hands on, and how much is it going to cost to get it out. That whole liquidity calculation, I think that's more problematic than valuation personally. So that's where you end up with difference of opinion. That's where judges jump in. And believe it or not, it's not all about value. There are other things. I mentioned loan accounts, business expenditure, tax issues, all these sort of things. They're all relevant issues. Sometimes SJE can come up with the right answer. Sometimes it's a thing to discuss. And so here's a couple of summary bits. You're going to get the slides. Key one, valuation. Is it right? Is it not? Should it be challenged? What's the most effective route? And personally, I don't always think that SJE is the most effective route, even sometimes when it's used. And what else is there going on? And more importantly, and the next job, handing over to Aaron, is do those valuation conclusions, particularly when you're talking about liquidity. Is that a practical conclusion that you actually work with to get the best outcome for your client? So at that point, I've handed to the two on a plate. So over to Aaron.
Thank you very much. Good evening, everyone. In the context of tonight's seminar, I'm going to be actually walking you through the primary corporate law mechanisms and options available. So hopefully at this point, the hard work and the hard yards have been done by the likes of David and the family lawyers involved in the matter. But typically, from a corporate law perspective, we get the exciting job of actually papering what the agreement or what's being commercially agreed between the parties. So I'm going to just talk you through 5 primary mechanisms, which I'm sure a lot of you have seen when drafting orders or working through matters for your clients. So the first one, it's probably the most common one, is actually the lump sum payment in exchange for a notional share of the other spouse's equity in the company. So primary benefit of that one is actually it limits disruption for the company, and fundamentally it keeps things intact, that preserves the company and the ability for it to trade going forwards. Usually, I'd say from experience, you've seen valuations which would determine a fair market value for those particular shares, and there's the process which David has just walked you through to get to the end position, whereby then you can go away and prepare the draft documentation for that. The next option or potentially neat solution is actually deferred payment. So to the extent a spouse doesn't have the capital available on day one to pay for the shares or the assets of the company, then there's certain instances where deferred payments may be quite neat and tidy in terms of solutions. So whilst the drawback of a deferred payment could be that one spouse wants to apply interest on that payment, in fact, what it gives is a degree of breathing space which can be plugged into the contract so that one of the parties receives the deferred payments over a period of time. In turn, a second sort of structural point from a company law perspective, and another sort of solution which gives greater flexibility, is actually to introduce a holdco within potentially an existing group. So the way in which this usually gets structured is that you would interpose a holding company which may sit above the current company which is in question. And what you would do is you would, the continuing shareholders will transfer their shares to the new holding company which gets incorporated in exchange for shares, in exchange for the issue of shares to the remaining shareholders. So effectively you're inverting such that you have a company structure at the top, thus allowing the exiting spouse to also receive their cash on day one, if required, or on a deferred basis. In that particular structure, holdco is effectively financing the purchase of those shares via the cash flow of the existing target company. So it limits again the disruption which gets caused or the need to have additional capital. The third one, which is in the centre of the slide, is around offsetting. So it's probably a term which I'm sure a number of you have come across, and again, from experience of what I've seen in various orders, is quite a popular solution in that it preserves the company's position for continuing shareholder whilst allowing them to give a fair degree of consideration to the other party by way of usually family home, pension pot. There's a big one available. The purchase of own shares. So this is under the Companies Act. There's a regime which is it's quite complex but multifaceted. However, under Chapter 4, Part 18 of the Companies Act, it permits a company to buy back shares out of its existing distributable profits. With that procedure, as I mentioned, it's quite strict. However, what it enables a company to do is to exit the particular shareholder if required or if desired, whilst being able to proceed with actually running the company going forward. So the process is quite, the process requires you to have certain requirements, or effectively you need to tick certain requirements off, namely that the cash needs to be available on completion, and that, as I mentioned, the company must have sufficient reserves. So as David mentioned, a lot of information can be gleaned from a company's statutory accounts. So the procedure or the process you would take is you go to Companies House, look at what's on their balance sheet, and then also follow up with the accountant to make sure that nothing's changed from the point in which they filed their last set of statutory accounts. And usually that's done by picking up a set of management accounts, which are more recent. But substantially, what the Act provides is that you can claw back or buy back the shares, usually at market value. And again, evaluation will come in handy to obviously determine what the fair market value is. But a few sort of cautionary notes around the procedure is that, and it often comes up in diligence when there's a corporate sale, to the extent that the company doesn't have sufficient reserves, then actually the buyback is void and is deemed as though it's never taken place. So essentially, you treat it as though the shareholder still actually exists on the register of members. So that can throw up a few problems in the round, and particularly when a company is looking to sell its shares, should it have not done it in the right order. But yeah, those are just some of the key points which are worth flagging. I suppose an additional one is also that on a buyback, you also have to pay stamp duty as well, so that needs to be factored in terms of the price and the costs. The last one, and it's very much a last resort option, which I think the courts tend to steer away from, and that's to proceed with a corporate sale. I'm not going to say too much about this because I think, as I mentioned, the preference is actually not to look to completely exit both shareholders or how many other shareholders there are in the company. But yeah, it certainly falls within as a consideration. The next slide is very much my hot tips or just points to raise, and I'm going to finish with a recent case study or matter which myself and Michelle worked on recently, just setting out some of the sort of safeguards and undertakings which we worked through in the context of pulling together an order.
Yeah, just to put it into a bit of context, this was a case where we'd agreed heads of terms at the FDR, and the husband had 2 dental practices, and he had one of these dental practices on the market for sale. And he very quickly agreed a 30% share to the wife of this dental practice. And we didn't think we were going to get anything out of this business. And just very quickly agreed. So we signed the heads of terms, and then we needed to draft the consent order. And we were so worried that he'd agreed so quickly. You know, what is he trying to hide? So we, came to Aaron, and in terms of the undertakings that he had to provide, things that we hadn't actually thought of. All of the disclosure that he has to give to the wife, to make sure that anything that he doesn't do could be enforced. So it was all about how to kind of tie him in and make him communicate everything that he was doing with the business, when he was selling it, all the movement around it. And so I think it would be helpful just to talk about that.
Sure. So there was a couple of limbs in terms of the undertaking that we looked to plug into the order. So the first limb is around information rights. So ensuring that wife is fully updated and informed in terms of receiving communication on offers that are being received, any letters of intent or heads of terms that may be negotiated or eventually entered into. Similarly, where a husband has got to the point where he's ready to instruct solicitor to act on the sale. And then the second limb is about documentation. So once the instruction's taken place, the solicitor, the key documentation from a corporate perspective being diligence, questionnaire and replies, and the draft contract, so share purchase agreement, as I said. And then disclosure letter as well, because that usually flags any additional sort of issues which may live underneath the bonnet of the company. Then I think the last one, most importantly, David, is valuation as well, whether that gets put forward at that point of the process. But turning to a couple of just other areas for a close. As you'd imagine, the structuring of the order and the corporate documentation kind of has to work hand in hand. So the order gives a fair idea of how the negotiations or mechanism, or the particular mechanism that's going to be used. But I think it's very worth also engaging with accountants at that point to make sure that there's sufficient liquidity for the company to operate going forwards, and so that there's enough income capacity as well for a particular spouse. The other key area around regulating future conduct, we often see clients come to us who want to put in place a shareholders agreement, and that will usually regulate the relationship between the shareholders and the company. And to the extent a non-participating shareholder or spouse wants to take a bit more of a passive role whilst keeping on the cap table company, this provides a key framework document to allow you to move forward, essentially. So the usual safeguards or the lens that you'd take is, what would a minority shareholder need in that scenario? And it covers similar points which we talked about months ago, about the right to information. These are board minutes, copies of management accounts once produced, and then it covers also reserve matters such as being a part of key decisions that get made in the company. For example, if the company wants to issue more shares, if it wants to change its constitution at one point. So those are the type of sort of decisions which may require a bit more of a passive or non-participating shareholder to still have a degree of involvement or input into, but it's again subject to negotiation and how things need to be structured going forward. That's everything from my side. So I'm going to pass it over to Olamide.
Yeah, I'm Miss Jolie, just to step up. I have the task of talking about procedure. It's probably stuff that you're more familiar with than what you've heard from David and Aaron, but still, yeah, still important to the journey that we have to embark on. So in terms of expert evidence and procedure, the procedure is, expert evidence is governed by Part 25 of the Family Procedure Rules. And in particular, when we're talking about financial proceedings, we also need to consider the Practice Direction 24A and B, as well as Practice Direction 25D, which relates to financial remedies proceedings, as well as other family law that don't cover. How do we get to admit expert evidence into the court? Well, we need court's permission. And in order to obtain the court's permission, we need to be able to prove to the court that the evidence that we want to obtain, or the evidence that we have, unlike children's proceedings, we can actually go and obtain a report. In order to use that report, we need permission to rely on it. So, is it necessary to resolve the proceedings? So, does necessary mean? So, James Monby, in the case of BHL, said necessary means necessary. It's an ordinary English term, and it's a word we are used to with family. So necessary is something that he goes on to say is demanded, as opposed to something that is reasonable or desirable. So that is that the information that you need is something that is demanded. It's not that I just want it because I fancy it, but it is needed in order to resolve things within the case. So in order to determine and consider the issue of necessity, the court also has other factors that it needs to consider. Essentially under the Family Procedure Rules 25.52, the court will consider things like the issues to which the expert evidence will relate to, the questions which the court would require the expert to answer, the impact which given permission would be likely to have on the timetable and duration and conduct of the proceedings. Any failure to comply with Rule 25.6 is also something that we need to consider, and that in itself is relating to the timing of when you make your application, or any direction of the court about any failure to comply with any direction of the course of proceedings. And the cost of the expert evidence is also a factor. The court also can consider the President's memorandum on experts in the family court. I won't go through those different points in detail, but one of the ones that would be considered, say for example, if you had your report in hand already, is whether the witness, that's the expert witness, is impartial in his or her presentation and assessment of the evidence. So, when should we make our application? Application should be made ideally at the time of the first appointment. However, there are exceptions to that. The first exception is perhaps you first of all need the responses to your questionnaires before you can determine for yourself whether or not an expert is needed. The second exception will be perhaps parties have agreed to the valuation of property for FDR purposes, but they've not been able to agree upon a value. And without any consent at FDR, the court can't make orders, so therefore thereafter you have to make an application to rely upon an expert. So the question is, can each party have their own expert? So single joint expert. So the presumption is in favour of single joint expert. And that's the starting point wherever possible. And paragraph 2.1 of Practice Direction 25D outlines wherever possible. And the case of J&J outlines that what that means is it is doesn't mean ideally or generally, it is wherever possible. And it should be appointed at first instance. So Daniels and Walton is really where I'm really moving to, because we're all used to the single joint expert, but there are cases where perhaps we decide, a party decides, actually I'm not happy with the single joint expert report. I want to get my own expert. is the party deterred from getting their own expert by the fact that we have a single expert? It is possible to ask for a secondary opinion from another expert, and that's what the case of Daniels and Walker outlines and gives guidance in respect of. The Daniels and Walker case is actually a personal injury case, it's not a financial case. And most of the cases that follow Daniels and Walker that gave us guidance are not cases that relate to financial proceedings. So the court will look to, as is outlined in the Daniels and Walker matter, the question of whether or not your reasons for seeking a further report is fanciful. So they shouldn't be fanciful if you want a further expert report. Another consideration that the court will look to is whether or not you have taken time to engage with the single joint expert report, and that's what paragraph 2 refers to. It doesn't want you as a knee-jerk reaction to read that single joint expert report and then decide, actually, I'm not happy with it, I'm going to make an application for a further expert. What you do is consider everything in a round. You'd be expected to put your questions in the usual way to the expert within 10 days of receiving the expert report, to question the expert in terms of perhaps what your concerns are in respect of the report that they've provided you with. And one of the other questions that the court will consider in terms of whether or not they will give you the opportunity to rely on a further expert is the sums that are involved in the case. So how do we determine if the reasons for seeking another expert are not fanciful? So the case of Proscove and Patterson, which is a case relating to neighbourhood dispute, not financial, gave us some guidance and factors that the court would need to consider. As you can see outlined there, it's the nature of the issue or issues in the case, the number of issues between the parties, the reason a new expert is wanted, the amount at stake, and if it's not purely about money, the nature of the issues at stake in the case and their importance, the effect of permitting one party to call further expert evidence on the conduct of the trial, the delay, if any, in making the application, and any delay that instructing or calling a new expert, any other special features of the case, and essentially the overall justice to the parties in the context of litigation. So how does this apply to finance cases? So I said previously that most of the cases that those practicing finance would have to have looked at are cases that didn't relate to finance. But in 2023, we have the case of GA and EL, and that in itself is a case that engaged with the guidance outlined in Daniels and Walker, and also subsequent cases that came out of Daniels and Walker in terms of providing guiding principles. And in essence, that case adopted the guidance outlined in Proscove and Patterson. So I won't repeat what is outlined here. But one of the factors that the court took in terms of determining that case was the most important factor in that particular case was the overall justice of the parties in the context of the litigation. So if I just speak a little bit about the case of DA and EL, it related to parties that were married in 2007. They separated in 2019. They had 2 children as a product of their marriage. And during the course of the marriage, in fact, a year after they married, the husband founded a software business with his business partner, and that was in 2008. In 2014, he transferred 30% of his business shareholdings to his wife. Basically, when it came to the point where they were in proceedings, they agreed the division they come to an agreement as to the division of the non-business assets, but they hadn't agreed on how the business assets would be divided. So, and at that point, the business had in fact been sold, and it was sold in 2022 for £35 million. So the husband's case was the value of the business increased once they separated. So the question that the court needed to determine what the husband was seeking for a single joint expert to determine was how much was that increase in value since they separated. So the single joint expert was appointed to assess the difference, the value of the business in 2019 when they separated. But the wife wasn't happy with the approach that the single joint expert had taken. So there are two approaches. One is what we call a present day approach. And that's the approach that the single joint expert took, and that's to look at the value at that time in 2019, not to look for anything that's happened since that date. The second approach, which the expert could have taken, and one that the wife wanted to be considered, was the hindsight approach. And that approach is based on what we know now. So we've got the 2019 figures, but also the actual figures going into the future. So the wife gauged, as Daniels and Walkers had outlined, with the expert and put questions to the single joint expert based on the hindsight approach. And so the expert was also able to provide his findings based on the hindsight approach. But that said, she still had gone and got her own expert report. And her expert had also provided her with figures based on the hindsight approach. So the single joint expert, on the present day approach, his own approach, had valued the business at 14.1 million. That's the business shares that the couple had, excluding the business partner. On the hindsight approach, he had valued it at £18.9 million. So it's a lot more than the actual present day approach. The wife's expert on the hindsight approach valued the business at 20.5 million. And so the wife sought to rely on that because there was a difference of £1.6 million. But interestingly enough, the court indicated that that amount in itself was a small percentage, if that's significant. When the court engaged with the case, the court just didn't look at the business on its own. The court looked at things in the round, it looked at the figures as against the open positions that the parties had put forward. And significantly enough, the husband's open position, he wasn't greedy. I mean, he wasn't saying that all the benefit was his. So that's one of the things that the court engaged in. And in fact, the wife's application failed. One of the reasons why her application failed was, and that's one of the factors to consider, was the issue of delay. The expert report came in July, we made our application in October, and her application was made less than 3 weeks prior to the final year. And so the court took the view that it would be, firstly, delay was an issue, but considering the justice to the parties, it would be an unfairness to the husband to allow her application. It would be unfair because the husband might decide that he wants his own expert. And given the proximity to her application in the final hearing, he may not be able to obtain his expert. And then another essential factor where we engage more than one expert in proceedings that needs to consider is the experts also may need an opportunity to engage with themselves to narrow down the issue. We call it an expert meeting. They'll narrow down the issues to see whether or not perhaps once they've discussed things, perhaps the parties in themselves will accept the position that they come to. So that was a factor that the court took into consideration. So interestingly enough, that is the GA and EEL case regarding the Daniels and Walkers application, but the actual final hearing was also reported. I won't go into that in detail, but only to say in the end, what the wife did get was about 42% of the business. So that's more than the 30%. So in conclusion, in terms of procedure, what you need to know is that it's Part 25 that governs matters. It's a question of necessity that the court needs to consider. Your application should be made at the first appointment unless it falls within the exceptions. The presumption is that you will instruct a single joint expert, all the things with that in terms of a joint instructing letter. If you can't agree on an instructing letter together, the court itself will intervene and determine the letter for you. And lastly, if you're not happy with a single joint expert, then you can make a Daniels application. But again, there are factors that the court will consider before it will allow it to proceed. Thank you.
So, Garden Court, hello. You've made it this far, and like every good seminar, there's a bit of audience participation. So, can everyone please stand up?
Wow.
Indeed. Okay, look around, take your shoulders, mind yourself, take your right hand, please, and tap it on your left shoulder. Well done for making it to this point. You've got one more talk to go. I can see sitting up here whose eyes have been drooping, who's warm in the face, and I am determined on the basis that I too have done slides, that my slides will be heard. Please sit down. Welcome to the last talk. I've got 12 minutes to give some nitty-gritty reality into some of the practicalities that when we've heard about this fantastic theory, when I try to apply it in my cases, what is the context of what the judge's indications have been and the reality of the human condition playing out with the structure that we as lawyers try and put in place. So I've come up with fun names for my cases, which I enjoyed a great deal. I'm calling this one the case of Mr. Dealmaker. In all the cases I'm going to talk to you about, there were long marriages and there were children, okay? This particular dealmaker, really charismatic guy, great with people. He had set up 3 separate companies and effectively, but they were training companies and he was a great deal maker. He operated in the UK, in Europe, in the Middle East. And when he came to me 2 years before the FDR, he'd even started at that point talking about how things were getting chilly, work was drying up, with a little glint in his eye, I have to say. And he had taken 3 separate directors' loans to buy a house once he moved out of the FMH. This was a case where my learned friend to my left, Mr. Muggridge, had done a report. And what I appreciated about David and what I learnt working with him and his reports in other cases, that he's very fair, which is one of the reasons why we asked him to be on the panel. In addition to taking directors' loans to buy a separate house, he had taken in cash 80K in the 2 years prior to the FDR. So he was running one argument about running down the company, but when he asked me to run that argument, I said to him, okay, you have told the court in your evidence that one of your major clients is a globally recognized company. There are articles about it in The Economist. What have you got for me that's going to evidence that there's been a downturn? He said to me, those are your instructions. So during the FDR, I said to the judge that he can take judicial notice of the fact that that company operates on the border between Russia and Ukraine, and that some of the work will be negatively affected. Ergo, my argument about a downturn. We use what we can use.
Did it work?
We got a settlement. It's not the most fun thing he asked me to do, which I'll tell you about in a second. The key thing that came up with directors' loans in that case was that the expert report quite properly identified that he hadn't paid the 80K back and the money that he had taken to buy that other property. So our client thought he was being clever by using directors' loans to buy a property mortgage-free. But in fact, my takeaway was it would have been much more attractive and persuasive for me to rock up with a hard debt to a mortgage company, NatWest nationwide, and say, look, his housing needs aren't properly met. Wife's got a mortgage-free property. He needs to be put in the same position. So sometimes we have clients who are trying to be too clever. And one of the things that David said to me in the run-up to this talk about directors' loans is that when they come up, it's really important to look behind the intention. And when I say to you about the intention, think about whether you have the evidence behind the intention you're trying to back up in court. So firstly, if there's an intention to repay the director's loan to the company, then it's probably correct to treat those funds as a surplus asset because the company has been trading without those funds. So what the judge said to me at FDR in that particular case of Mr. Dealmaker, he said, well, Mr. Liu, he's got a mortgage-free property. He hasn't paid the director's loan back. by the way, HMRC's probably got something to say about him not complying with the 9-month and 1-day rule. So I'm just going to take it on the chin that he's going to pay that money back and the company's actually worth a lot more. Think about that while you're trying to not give the wife as much. But the second thing to bear in mind in terms of intention is if the intention behind the director's loan is that it's little more than an attempt to delay in declaring dividends, then that's a tax mitigation strategy. And if the rationale is justified in that way, then there could be an arguable case that the director's loan is not a surplus asset, and therefore it will not increase the value of the company. So in my next slide, I make a general observation about running down the company and how that can have cost implications for your client if you're the person trying to run it down. Obviously, what can happen, and I've seen it happen in other cases, is that the wife will grab you by the scruff of the neck, not take litigation loans in order to run you down evidentially, and there might be findings that you've engaged in litigation conduct where you perhaps have made the company liquidated and moved the assets elsewhere or made it bankrupt. And if the court cannot find where the money has gone, then the court may deem that the husband has a benefit of those company assets. That approach can lead to increased costs for both parties and potentially a wasted cost order against your client if they're trying to conduct themselves in that way. I flag up that, again, people like David Muggridge, as he did in this case, he identified the director's loan sort of cover-up for exactly what it was. And little things like, if you're using a director's loans to buy Skittles when your company is one that buys flowers, it's a bit of a red flag. One of the things that worked in that case, and it's something to think about if you're dealing with somebody who uses their company and takes a lot of cash out, what he had done, to his credit, was that he had remained consistent with how he took petty cash out and spent it prior to separation and how he dealt with that post-separation. Because although I've alluded to the fact that the cash withdrawals were very high relative to the turnover of the company, because it was consistent and I had the evidence from the accountant to show that he hadn't just been taking cash out to reduce the matrimonial pot, the judge gave an indication in my favor at FDR that there was nothing to see there in terms of the wife's argument. However, the thing that I needed to say with a straight face when the wife's counsel said to me that my client had spent 25K in 2 weeks, my response to that was, Your Honor, Christmas is a very expensive period. And I moved on. It didn't stop us getting a settlement, which was really good. So it's been said before, but judges will be giving weight to the suggestion that spouses who say, well, you know, things have been very difficult just before separation and they're not necessarily going to improve. It's similar to when we run health arguments under Section 25. You know, my client's anxious, my client's got depression, my client's in therapy. Judge will say, well, that's because they're in divorce proceedings. And hopefully, when they're done with those, they'll start feeling a lot better and business will improve. So you have to prepare your clients for that. Basic things about how you can set up the chessboard so that the game can be played fairly and that you've got more arguments to put into play later down the line, is that if there are going to be loan agreements during the currency of proceedings, ideally even before separation, then of course we want those loan agreements to be formal, signed, dated loan agreements, witnessed, notarized, because it reduces arguments about, you know, who contributed what, is a loan a hard loan or a soft loan. Try and make sure that where we can reduce those arguments and grey in litigation, we sort that out. What I've had to argue on behalf of wives often is that where there is a clear nexus between the parties' separation and a company's decline, I've had to sit down with Michelle and really think outside the box in terms of what directions we can seek so that we can give the widest possible evidential basis to gain an understanding of how the company was functioning prior to the separation. You know, when the marriage was good, everyone was happy, how much money was he really making? Because that's to achieve fairness. When you are thinking about setting up the company, often people will make their spouse a company secretary and not really think about it. They just do it because it's easy. But it gives the spouse who's the company secretary the opportunity to argue that they have been hugely significant in terms of the operational functionality of that company, which, as we all know, may or may not be true. So if you can think about someone else to be the company secretary, maybe that's going to reduce the arguments later on. I've called this case lighthouse swimming because I like swimming and I like lighthouses. It'd be nice to swim next to one day. In this case, we had a husband who I was for, who previously worked in finance. His wife had been an expert swimmer when she was a child. Her mother was also an expert swimmer and was an expert professional coach, fantastic reputation nationally. So he quit his job and he told me in conference, I built that pool with my bare hands. And he spent a lot of time explaining the bricks and mortar of how the pool was built. He put in a cafe, he took the COVID loan, he built this other part of the business. He was emotionally connected to the swimming pool and all he had done. David Muggridge took away all the emotion from that venture. David said, this is a swimming pool. It's worth this much. If you put it on a market, this is what it will sell for. The cafe is lovely, but it doesn't really change the global figures in terms of the wife or the husband buying each other out. Clearly, David wasn't in the conference. So it wasn't just a case about a swimming pool, because there was a plot twist. There are a couple of plot twists, but I'll tell you the first one. The pool was bought with a mortgage, and the mortgage was in the name of 4 people. Child's maternal grandparents, told you, expert swimming coach, my client, and the wife. And the title deeds for the property, for the swimming pool, was in 4 names as joint tenants, which is all fine in the good old days when everyone's happy. The deposit was paid by the husband and wife, but upon divorce, everything falling apart, people falling out, it led to Talata issues. Massive Talata issues, because my client, the husband, accepted, actually, though I built this pool with my bare hands, I would not have been able to purchase this property with my wife were it not for the previous business experience of the maternal grandparents who'd run a swimming club. The mortgage company just said, we need them on the title deeds and on the mortgage, otherwise we're not giving you the money. The other plot twist I didn't put down here was that there was an alleged fraud by one of those 4, which, if found during the fact-finding process to figure out the Talata issues, could have led to criminal proceedings against that family member, if the matter had not settled. It did. But the reason why I flagged that is because one of the 4 was arguing, if I'd known about that fraud, I would never have entered into mortgage and title deeds with that person. But it is another reason why we flag up some of the don't do's or do differently so that you can think about these points for your cases. One of the things I'm going to come on to say is that really standard stuff. If they had bought that property together and they intended, the husband and the wife, to own 50-50 split of the beneficial interests, they could have just had a deed of trust running alongside the office copies entries, and they didn't. The added complication to that case was that there was lots of evidence that everyone thought was really important about deeds of retirement. And I highlighted in conference that there were 2 different sets of deeds of retirement with 2 different sets of figures, and the date didn't correspond to the chronology that anybody was talking about. And how that would have played out at the final hearing is the judge would have said, well, you're all involved in the business. ultimately the maternal grandparents didn't get any consideration identified in any of those documents. So query whether that sort of document is really going to help you if you're involved in business with family. What David did well, which helped the settlement, was that he gave us a computation on a cash figure that either party could raise to buy the other out. And ultimately, because of the risk of findings, because of the risk of criminal proceedings, that was an out that actually did give way to the maternal grandparents falling away, and it was something that reduced the issue about contribution. So well done, David.
Loving this, carry on.
So moving over, some of the hindsight takeaways is that if you go to someone like David, they'll say, well, it's the most tax efficient thing for a spouse to get a salary from your company. No, I get it. And that's the default approach in so many of our cases. But I still think we should be telling our clients to pause and reflect about whether we want to give the spouse a salary just because it's tax efficient. And one of the ideas that Michelle had leading up to this was, well, actually, why don't we do away with all these arguments by having it set out in a prenuptial agreement how the shares are going to be dealt with, how the income is going to be dealt with, especially if children are involved, or a postnup. And then one of the things that I thought about was that when you're incorporating the company to begin with, why don't we put it into the agreements that a certain amount of shares that you know, default and instinctively you want to put in your spouse's name, why don't we create a trust for the children from the outset? Because like I often find when I'm negotiating an FDR, etc., is that accounts that are for the children or with the idea of tertiary education or university or a house deposit, they are often less controversial as bargaining chips. And so it reduces potentially some of the arguments. It's been said, but I'll repeat it. I find it much more informative to be looking at business accounts and how people have really spent their money. And I find that more revealing than the company accounts and Companies House. So think about whether you want to get those. Mr. Eco Warrior in Brighton, he was on the other side. And effectively, he had what we've all described as an income generating company. It's him, laptop, his Wi-Fi. And the history of his consultancy was that his main client was an employer where he had been a senior environmental consultant. So what I said was, why do you spend 50K on marketing? They know who you are, which the judge accepted. Not only had he spent 50K on marketing and spent that money on 2 employees who were experts in marketing, but my client, diligent as she was, went on LinkedIn and discovered that those 2 individuals were working for husband's new partner, pro bono. And they'd said that on LinkedIn. We asserted, which the FDR judge accepted, that actually he was using his company as a mechanism to pretend like he's got less revenue and to pay the ex-partner's employees, which was not okay. So the court was suspicious and gave an indication in our favour in that regard. The next case I want to talk to you about is the king of Kathmandu. I love Kathmandu. When I went there, they asked me if I was from the Lowry tribe, so I feel very at home. The reason why I chose that name is because this company has a big office in East Asia. And it was a long marriage, 3 children. And what I want to say about this case, I'm going to tell you the thing I was going to say at the end, at the beginning. Most times in our cases, you have the divorce when the children are younger. Yeah, you have the separation, you have the divorce, it all happens in quick succession. And both parties sometimes leave feeling bitter, The relationships are fractured, sometimes irreparable. The children don't want to talk to their husband because the dad because they feel that their mother's had a hard time, vice versa. But what was really interesting about this gentleman when he came to meet me is that he'd done it the other way around. To keep family relationships really golden, really calm, really compassionate. And he maintained really good family relationships with the children, with his ex-wife. But now, 17 years later, having had the benefit of keeping those relationships sweet, he's realized that there are advantages and disadvantages to that. Because he now wants there to be equity accounting for how he was being generous financially post-separation. He wants to point to separation agreement that was drawn up close to the nexus of separation. And Michelle and I had to tell him, you can't have your cake and eat it, I'm afraid. You can't hold the wife to a separation agreement that wasn't legally binding, that didn't have financial disclosure, it's not REBMACA compliant. And you've benefited from those familiar relationships, that's great, your kids love you. But I found that really interesting, and so we're working through it. But the facts are that some of the elements of compassion that I want to speak into this seminar is that they remained close friends. He didn't judge her for having had an affair with her PT. They treated each other with compassion. They helped each other through bereavements of their parents. There was a lot of love. They co-parented together. But as I said, there was a separation agreement and it wasn't legally binding. The limited company was set up during the currency of the marriage and it operates internationally. It's a matrimonial asset at that time. Not only did they remain good friends in the way I've described, he said, I trust you so much. I want you to make international payments for me post-separation. You don't have any shares in the company. You're not a director, but I trust you. And he accepts in his Form E that was important to the company running at the time. The good thing for him financially, but the fly in the ointment, is that for round figures, let's say the company had a turnover of 100K at the time of separation. The company now has a turnover of 5-6 million 17 years later. And so wife is saying, well, I want to pretend like we're separating now. I want a bite of that cherry now. 2 minutes, nearly done. And so what are some of the hindsight takeaways that I wanted to talk you through?
Stephen, just on that case,
Thank you.
it all went sour when the husband had a new partner. So it was just really interesting that everything was going really well. And as soon as he met somebody else, it all went really badly. And that's when she started making a fuss and then issued her applications 14 years later. So what we're arguing in that one is post-separation accrual. We're going to be arguing against evaluation, which the wife wants at the FDA in a couple of weeks. So we're going to say it's not necessary to have evaluation because it's all post-separation. So we're going to be kind of trying to argue the opposite in terms of, you know, we don't need evaluation. This is just husband, just him. And he wants to retire. He wants to gift the business to his daughter. You know, the husband and wife agreed that, you know, many years ago, and now everything, now she wants a piece of everything. So that's, you know, it's all good until it's not good.
And I'm really glad that you've added in the human element of that, because the structure we talk about, it's all relative to the human condition that we all have. And that's a really important feature. One of the things that struck Michelle and I as takeaways were that, of course, you all know, if there had been a proper consent order, proper financial disclosure back in 2003 when the husband thought, well, I thought this was a separation agreement, which, by the way, the agreement they came to, he paid all of that money that he promised to pay. He was true to his word and he was true to the substantive aspect of that agreement. But we all know, that's why we're in court in a few weeks, that it wasn't lodged with court, they didn't have proper lawyers draw it up, they can't rely on it. Our main argument is post-separation accrual in the business, which will weigh against the wife. The problem for our husband in this case is that there was no formality around her role in the business. So he's obviously arguing she just made a few back payments. In her replies, she sounds much more intertwined with the intricacies of exactly and precisely what he was doing on the technical level, which we'll have to tackle with. The court ultimately, though, as DDJ Elliot said, might just look at both of us and say, worried about, you've got a lovely flat in Thailand, huge, humongous flat, and you both have mortgage-free properties in the UK, you're in your late 60s, you've got a pension, what are your needs? These are the resources. I'm not sitting here listening to you, you've had a great life, don't ruin it now. So we shall see. That's more like my education. But so I say, if your spouse is going to be in the company, you need to future-proof that situation by really being clear about what their role is with an employment contract. The added complication in our case is that not only that, but there was no policy document setting out how company funds could be used. So one of our evidential matters which we'll be raising is that the wife, as she got to a certain big number, decided to take the company credit card, tick off her bucket list all around the world, rent the most fabulous properties, and have a great time.
Now she's put that in her budget. Now she's got this holiday budget because she's been doing it the last 40 years, and she needs, what figure is it, Olivia? She needs about,
She's been spending what 20k a month on travel, but
yeah, and now that's part of her, need. So it'll be interesting.
Wouldn't that be nice,
I know.
ladies and gentlemen? And so that is all I wanted to share with you. I hope that brings some of the points raised by my learned friends to my left together. Thank you for being here. Thank you for sitting through this. We're very honored you're here, and thank you for listening.